These are some of my favourite pieces of literature. Days That Changed the World, The 50 Defining Events of World History, Speeches That Changed the World, The Stories and Transcripts of Moments That Made History, and Women Who Changed the World, 50 Inspirational Women Who Shaped History. Also a very important book for Australia, Australia's Constitution, Time to Update. This book is a summary of the reports of the advisory committees to the Constitutional Commission. It was published in September 1987, and members of the Commission, including the 5 advisory councils, the Constitutional Commission consisted of Sir Maurice Byers, former Solicitor General for the Commonwealth, Professor Enid Campbell, Faculty of Law, Monash University, Sir Rupert Hamer, former Premier of Victoria, E.G. Whitlam, Gough Whitlam, former Prime Minister, Professor Leslie Zines, Faculty of Law, Australian National University, and the Honourable Mr. Justice Toohey, who was then a judge of the Federal Court of Australia, was a member of the Commission until 31st December 1986, when he resigned in view of his appointment as Justice of the High Court of Australia. That's the Constitutional Commission involved in publishing the findings in this book. Also 5 advisory councils. Australian Judicial System was one council. Mr. Justice D.F. Jackman, Professor James Crawford, Mr. Justice W.M.C. Gummo, Mr. Roger Jennings, QC, Mr. Justice G.A. Kennedy, Mr. Justice R. McGarvey. The second committee is Distribution of Powers, Sir John Moore, Dr. Breen Creighton, Donald Dunstan, QC, Jack Ferguson, AO, Jeff Lindell, Paul Munro, George Polites, Haddon Story. The third advisory committee is the Executive Government, was the Committee on Executive Government. Sir Zelman Cohen, QC, Kim Beazley, AO, Professor Donald Horne, AO, Susan Kennedy, Sir James Killen, David Solomon, John Wilden, Associate Professor George Witterden. A lot of these are former politicians on these committees, politicians and judges and QCs. The third advisory committee is Individual and Democratic Rights. Mr. Terence Purcell, Mr. A.R. Caston, QC, Mr. Russell Clark, Miss Rhonda Galboli, Mr. Peter Garrett, Mr. Thomas Keneally, AO, Dr. Paolo Totaro, and Professor Eric Wilmot. And the fifth advisory committee on the Constitution for this study is Trade and National Economic Management. The Honourable Mr. Justice M.G. Everett, Mr. Bob Bakewell, Mr. Mark Burrows, Associate Professor Michael Coper, the Honourable Dr. Rex Patterson, Alderman H.G. Percival, and Miss Philippa Smith. Former politicians, former judges, former lawyers or professors in law, and a lot of very well educated people prove that the position of Prime Minister is not stated in the Australian Constitution. I'll read a little bit of the analysis that was published in this book. Well, the Constitutional Commission terms of reference were to inquire into and report on or before the 30th of June 1988 on the revision of the Australian Constitution to A. Adequately reflect Australia's status as an independent nation and a federal parliamentary democracy. B. Provide the most suitable framework for the economic, social and political development of Australia as a federation. C. Recognise an appropriate division of responsibilities between the Commonwealth, the states, self-governing territories and local government. And D. Ensure that democratic rights are guaranteed. For the purpose of conducting hearings, 3 members of the Commission shall be sufficient to constitute a quorum. Where there is a division of opinion within the Commission, the majority opinion shall prevail, but if the Commission is equally divided, the opinion of the Chairman shall prevail. During the course of their inquiry, the Commission shall 1. Seek the views of the public and business, trade unions and financial institutions. 2. Hold public hearings and sponsor public meetings to ascertain the views of interested organisations, groups and individuals on constitutional reform. 3. Stimulate public discussion and awareness of constitutional issues by circulating draft proposals and putting forward initiatives and views on constitutional reform. 4. Make interim reports on matters under study at intervals to be determined in consultation with the Attorney-General. And 5. Consult with and evaluate the reports and recommendations of advisory committees which are established to examine specific subject areas of constitutional reform. These are the findings. This is a summary of the findings of the Constitutional Commission and the 5 advisory councils associated with this, conducted over a period of about 5 years during this period, or leading up to this period. Most of it has not been implemented, and the way the current Liberal and Labor politicians are running the federal parliament is totally outside the Constitution. And I'll prove that in the findings of this Constitutional Commission in this time, and also the 5 advisory councils. So I refer to extracts of this analysis, the summary of findings, summary of the reports of the advisory committees to the Constitutional Commission. It's an excellent resource. Provides excellent evidence that the current politicians are not running the federal parliament as it should be, and that there are a lot of problems in Australia in relation to the way that particularly individual rights and freedoms are destroyed by the politicians, really, and that reform is required to really to create a better constitutional framework for Australia, and in particular to increase the rights and interests of people who suffer in our society, I believe, particularly Australian-born people who really get overpowered by abuse of power within the government in Australia. I say that as a teacher, and also an analysis of the findings in this book. I refer to page 40 of this report, and they deal with head of government. So the findings that has been presented in this book is a result of the people involved in the Constitutional Commission, and the Constitutional Commission being a commission within itself, and then 5 advisory committees in addition to that commission. And this is what they write. Section 61 of the Constitution provides that the Governor-General exercise the executive power of the Commonwealth. Section 62 provides that the Governor-General is advised by a Federal Executive Council, whose members hold office during his pleasure or her pleasure. And if read literally, Section 64 provides that the Governor-General may appoint anyone as a minister, but that the person cannot continue as a minister for longer than 3 months unless that person is or becomes a Member of Parliament. These sections provide a misleading picture of the way in which the present system of government in Australia actually operates. So they're not operating, the politicians are not operating within the parameters and guidelines of our Constitution. The confusion is compounded by the fact that there is no mention of the existence of Cabinet as a body different from the Federal Executive Council, or of the office of Prime Minister. nor is there any explicit statement of the core principle of ministerial responsibility to the House of Representatives, although this is implied in the Constitution. So essentially, under our Constitution, it's the Governor-General who appoints ministers in the Federal Parliament, not the Prime Minister, and the position of Prime Minister is not stated in our Constitution, so that's a big problem that we have. It is the Governor-General who holds the power to appoint ministers and dismiss ministers, including the Prime Minister, and also the position of Governor-General must be a lot more involved under the Constitution. The Governor-General has to play a greater role in the political process and management of Australia. That's what's required under the Constitution. And it's not the Prime Minister who appoints ministers. The position of Prime Minister is not even stated in the Constitution. The committee believes that some minimum statement of the general principles of parliamentary executive government is essential. The committee recommends that an explicit statement that the head of government is the Prime Minister be added to the Constitution. The Constitution should also state specifically that when the Governor-General appoints or dismisses ministers, he should do or she should do so on the advice of the Prime Minister. This is simply a description of what happens now, but it should be explicitly stated as a democratic safeguard. For similar reasons, the committee also recommends that the principle that a government holds power by maintaining the confidence of the House of Representatives should be written into the Constitution. So, we have problems in Australia politically where the current politicians don't follow the Constitution. I'll also read out a statement made by Professor Colin Howard on Australia's Constitution. Few countries can be so dominated by a printed document as is Australia by its Constitution. Few peoples can be so plagued with constitutional problems in their daily lives as are the Australians. Mostly the problems are not recognised as constitutional. A dull, remote and incomprehensible document like a printed constitution seems to have no connection with life as it is actually lived. This appearance is misleading. The Constitution has everything to do with life as it is actually lived in Australia. So in effect, the section that they provide on head of government in Australia really provides that the Federal Executive Council of the House of Representatives, there is to be a Federal Executive Council of politicians formed in the House of Representatives who govern Australia, who provide leadership for Australia, not just one person, not the Prime Minister, it's not stated in there. That is being referred to in modern times as the Cabinet. Okay, it's not the correct term. There is no word cabinet in the Constitution. The correct term for the body of politicians in the federal lower house who are supposed to provide leadership to the nation as ministers and also work with other ministers that are appointed by the Governor-General is called a Federal Executive Council. It's not called a cabinet, and there is no explicit position of Prime Minister in our Constitution. So I believe that creates problems for the way that Australia is governed. And in effect, what should happen under these provisions, where there's a Federal Executive Council of politicians in the House of Representatives, have ministerial roles, obviously, and also other politicians are appointed ministerial roles. Every politician in the lower house really should have a ministerial role. They should have only one ministerial role in the state parliaments as well, so that there is real accountability for each politician, that they have one ministerial role, one portfolio to be accountable for, and they are fully accountable for that portfolio. The problem with our current political system is that it's very difficult to enforce accountability for politicians other than voting them out. So that's problematic. It also provides for, in reality, under the Constitution, what should be happening in the Federal Parliament, in the House of Representatives, is that each politician has a ministerial role, which is appointed by the Governor-General, and overseen by the Governor-General, there needs to be provision made for, if there's going to be a Prime Minister appointed, it has to be appointed. There has to be provision for it in the Constitution. And it's Section 128 where a referendum can be called to make constitutional changes to implement these recommendations. Obviously, billions of dollars have been put into this and nothing's been done about it. So I don't believe our federal parliament, I believe it's not functioning effectively. And what would be, in reality, what would be in conformity with the Constitution is if every lower house member, House of Representatives member in the federal parliament had a ministerial role, that every time the parliament meets they should be giving a report to the Australian people, the public, a 15-minute report on their ministerial role, what they have done as a minister to fulfil their duties. Also, politicians who don't have a ministerial role should be making a report every time the parliament meets to give an account of the work they've engaged in their electorate, for their electorate. That would be a suitable application for the current Constitution and the way it's supposed to function, not what is currently being engaged in our parliament. When we see on the television, the conduct of the politicians is disgusting. And all they do is have two groups, you know, a government in office and an opposition, which is not a constitutional concept. There's no provision for an opposition in the Constitution or for a government in office necessarily to have all domination, and for that domination primarily to be engaged by one minister, a Prime Minister, when the position of Prime Minister is not even stated in our Constitution, and this is evidence. So they are dominating the Parliament, and it's all about that one person, that Prime Minister. I don't think so. And also about an opposition leader or an opposition leader of an opposition party. That's not a constitutional concept. And every minister in the Parliament should be providing a report to the public, a 15-minute report, giving an account of the work they've engaged as a minister for their area, in the area of education, in the area of, you know, the Treasurer should be providing a report, in the area of health, the area of housing. There should be a minister for homelessness, I believe. There should be every ministerial role for trade, for economic development, for, you know, workplace relations. Every ministerial role, when they're meeting in the Parliament, every minister should, in an orderly fashion, provide a written report and an oral report to the Australian people, which is televised live, very heavily by the media. It should be heavily televised, and every time that Parliament meets, every minister should give a report, 15 or 20-minute report on the work that they've engaged, to give greater accountability. And every other politician that doesn't have a ministerial role should give a report to the Australian people, a 15-minute report to provide evidence of the work they've engaged in their electorate. Not what's currently being provided, where they're going back and forth between two so-called leaders and just slinging off at each other and playing political games. There's no accountability. It should be done in an orderly fashion, that the Speaker should call every minister by name, by position and by their electorate in an orderly fashion, and then in an orderly fashion every minister give a report to the public, because that's what they're there for, to give an account to the Australian people. But what we are currently seeing is nothing but badgering and game playing and slinging off at each other, and there's no accountability, and it's totally irresponsible. It is outside the parameters and framework of the Constitution. And the Governor-General should be stepping in and overseeing that the conduct of ministerial reports and non-ministerial reports given in the Parliament are provided in an orderly fashion, in an objective fashion, and it should be one up, give you a report, next one up, give you a report, next minister up, give you a report, next minister up, give you a report, in an orderly, constructed fashion, so that the Australian people can see some sort of accountability, proper accountability going, because there is none at the moment, absolutely none. And our people are suffering There's not enough jobs for the Australian people. There's too many homeless people. People have committed suicide in this country. It's criminal the way they're using this parliament. It is absolutely criminal. I was born in Western Australia. I've been teaching for 17 years. I've taught politics, economics, judiciary, legal studies, social studies, physical education. But I'm telling you, they're not using the parliament properly. There's no responsibility, there's no accountability. It's just a game for them, and people are dying. And there has to be accountability. They should be voted out. I'm asking all voters in Australia to give your number one vote to someone else, another party, an independent. I'll be contesting the federal election with the United Australia Party, Palmer's United Party. Give your number one vote to another candidate. Give your number one vote to another candidate. It doesn't matter about the party. What matters is the candidate that you're giving your vote to. Do you know the candidate? Have you had a conversation with the candidate? What do you know about the candidate or the candidates in your electorate that you are voting for? Not the party. The party doesn't mean anything. It doesn't mean anything. It's the candidate that you're voting for that's important. And I'm asking you to give your number one vote to other candidates and put Liberal and Labor last and second last, because they have got blood on their hands, and it will never change unless the voters change the way they vote. So here's evidence that they're not running the federal parliament in accordance with the Constitution. There's other issues that this report and analysis, lots of issues that this report and analysis raises. One in particular, which I have a special interest in, is the issues that this report raises regarding the Constitution are widespread. And some of the issues that were really they focused on were Australian freedoms, the present framework. Section 51 requires the federal government to provide compensation on just terms to any state or person whose property is compulsorily acquired. That doesn't happen. Section 80 guarantees trial by jury for those indicted under federal law. That doesn't always happen. Section 92 guarantees free trade amongst the states. That pretty much happens. Section 116 prevents the Commonwealth from enacting a law to establish a religion or prohibit the free exercise of religion. Section 117 prohibits individual states from discriminating against interstate residents. And Section 117 and 92, Sections 92 bind the states, but the other provisions apply only to the Commonwealth. This report and analysis addresses issues to do with traditions and common law, evidence about rights. In written submissions and during public hearings held throughout Australia, the committee received evidence about breaches of fundamental rights and freedoms. These included the status and privileges of citizenship, the value of a vote, interference with the peaceful enjoyment of property, free exercise of religion, legal process, which most Australians don't have access to courts because the cost is prohibitive, and the judges and magistrates are just working for the government and they're working for the corporate sector. Free speech and assembly, and the physically or intellectually disabled. So written submissions and public hearings that they received evidence about breaches of fundamental rights and freedoms in those public hearings and the submissions that they received. And I believe since the 1980s, 1987 when this was published, the situation in Australia's got worse. Look at the crimes against the Aboriginal people. Government and judicial crimes against the Aboriginal people are horrific. And other Australian-born people who are born here, the way they lock people up in psychiatric facilities is criminal, the way they do that. The way they let people suffer from homelessness and suicide and all these social problems. It's criminal, the way that they're allowing people to suffer in Australia. And a lot of it has to do with the way the parliament is being run. The issues that were addressed in the report were to do with the preamble of the Constitution. The people, the Commonwealth of Australia Constitution Act commences with the words, whereas the people. Thus the legitimacy of the Australian Constitution derives from its origins as an instrument approved directly by the people for the purpose of creating a new nation. This fundamental aspect of its legitimacy is confirmed by the provisions for change contained in section 128, which insists that the Constitution may be changed only by the people acting by referendum. The reference to the people recurs in other sections. Other issues address limits on powers of the government, other matters of fundamental importance. Democratic principles are fundamental to the way our governments exercise power. Thus, it is essential to ensure that voting and elections for federal and state parliaments are truly democratic, which I believe they're not. The committee believes that amendments to the Constitution are desirable to ensure that democratic processes are preserved. Where they've indoctrinated the people, Liberal and Labor charade, two-party preferred, is a total indoctrination of and a breach of the fundamental rights and freedoms of a true democratic society. So they've corrupted that by brainwashing and indoctrinating everyone to vote Liberal and Labor. Well, that's not democracy, is it? It's more like totalitarianism. Apart from democratic processes, there are two major areas in which the committee has concluded that the Constitution should be amended to prevent governments interfering with the lives of Australians. These are, first, additions to procedural justice, provisions in the Constitution such as Section 80, trial by jury, and secondly, by restricting governments from interfering in such matters as religion, movement, expression, freedom of expression, and equality before the law. So there is huge government incursion into the rights and freedoms of Australian citizens. They stop you from speaking freely on political matters. Even the High Court is starting to do that now, the judges. So we need political and judicial reform in Australia because it's not working. The judges are breaching the rights and freedoms of Australian citizens and magistrates as well. The politicians are doing it, and so are the judges and magistrates. They abrogate all principles of procedural fairness. They abrogate principles of common law. They abrogate principles of natural justice, and they abrogate the principle of legality, which the submission I filed with the Supreme Court, 77-page submission, and I filed a 17-page submission as well. The 77-page submission I filed, which I'm going to read out on YouTube in the coming years, talks about how they, in the courts, they don't provide procedural fairness for citizens. They don't apply common law principles. They don't provide natural justice principles. They don't apply principles of legality. It's very one-sided. I've seen transcripts. I've seen people, the way they're treated in courts. It's horrific. It's disgusting. And often people don't even have a lawyer representing them. So the government magistrate sides with the government lawyers or the corporate lawyers. And I've seen transcripts where people have been told to shut up. They don't have a lawyer helping them. Innocent people fighting for their property rights, stopping the banks and the government taking their homes away. I saw evidence of that in the court, in the Supreme Court, and also in the District Court and the Magistrate Court. When I presented to the District Court, the way I was treated, one judge ruled in my favour, the others didn't. But being a teacher, I got treated like garbage, you know. There was no discussion ever of providing any lawyer for me when I was fighting the state solicitor's office. You know, the judges are letting 6 versus 1, in my case in the Supreme Court, for political signage. They allowed the government, the judge Hall allowed the government to Attorney General and government lawyers, Solicitor General, State Solicitor's Office. It became a case of 6 versus 1. So how is that procedural fairness? How is that natural justice? How is that applying principles of legality? It isn't. How can judges do that? Conduct a hearing where there's absolutely no equality at all. So we need reform in the judicial system. Other issues that were constitutional issues, legal issues, rights issues that were discussed in this obviously extensive study and analysis: deprivation of liberty or property, trial by jury, presumption of innocence, which doesn't really exist in Australia anymore, self-incrimination, double jeopardy, bail, searches and punishment. It's too much on the side of criminal law. It's like convictism still, really. Australians and civil rights, freedom of religion, which has just been destroyed by the Attorney Generals around the country and the judges in the High Court. 5 out of 6 judges for the Commonwealth brothers destroyed freedom of religion, just like that. Politicians, Liberal and Labor politicians, using tax money in their position to destroy people's rights, the rights of Christians. So that's obviously an abuse of power, very corrupt, to be using their position, Attorney Generals using their position, and judges using their position in the High Court. Example, the Commonwealth brothers. Example, what happened in my case in the Supreme Court. Made it 6 versus 1. Me being the one. I still beat them anyway, but, you know, obviously educated, intelligent. There's a lot of people that don't have those skills, and that's the problem. You know, using millions of dollars, politicians using $1 million going to the judiciary and destroying people's fundamental rights and freedoms in Australia. Freedom of religion, freedom of speech. It's appalling. Freedom of movement was another issue. Freedom of political speech. Freedom of speech is not guaranteed by the Constitution now. They were saying this back in 1987. The committee has given careful consideration to the problem of defining the area of speech which would be appropriately protected. The underlying aim of the restrictions on government power which are recommended by the committee have been to enhance the democratic process and to ensure that basic freedoms which are accepted as common values remain unimpeded. But they're not unimpeded. They're engaging in abuse of power to destroy fundamental rights and freedoms, including freedom of speech and freedom of religion. So it's not working. There is no restriction and limits on government power in Australia. They have way too much power and they're abusing their power. There are obviously substantial fields in which governments should properly be permitted to regulate various forms of speech. Example, defamation and obscenity. But even then, defamation is a question of evidence and truth. So freedom of speech is a lot more important than defamation. Because if you're freely speaking about injustice in our society, where people are dying, like the homeless people, and other people locked up and being drugged and killed with dangerous treatments, if that hurts a few people's feelings or causes a bit of defamation, that is not an issue. The issue is the government's use of their position and tax money to kill people or destroy people's lives or fail to provide basic services like accommodation and housing for citizens in our nation. That is more important to speak freely about those issues than any concern of defamation, because the people who are accountable deserve to be named. The Australian people have a right to speak out about these issues of injustice, and they have a right to name the people, in the political people and the judicial people, who are failing to provide proper leadership in this area. They should be critiqued. So freedom of speech is a lot more important than any other issue. The area of speech and expression which deserves constitutional protection from interference by government actions is the field of political speech. The Constitution should prevent governments interfering with any form of speech which deals with the political process and with issues which concern the functioning of government, public policy and administration and politics. And that is the recommendation of this Constitutional Commission and 5 advisory councils to the Commission. Freedom of information was another issue that was analysed. The committee believes that a democracy cannot function properly if governments can keep any information about what they are doing from the public. The committee believes that some limits should be imposed on the power of governments to withhold information. The courts would be able to decide whether the government was being reasonable in withholding information. The government would at least have to justify its decision, although of course the courts would give considerable weight to the government's views. You see, that's evidence that the judges too much in the favour of the politicians, so the citizens hasn't got a hope in hell. Peaceful assembly. Many people regard the right of peaceful assembly as fundamental to a free and democratic society. Some states in recent years have limited the opportunity for peaceful assembly. It should be guaranteed by the Constitution, is the recommendation. Citizenship. The Constitution currently does not recognise the status of Australian citizen or acknowledge the notion of separate citizenship for Australia. The committee recommends that the status of citizen should be provided for and protected in the Constitution by including in the Constitution a provision in the following terms. Section 126A, all persons who are born in Australia, number 1, born in Australia, 2, natural born or adopted children of an Australian citizen, and 3, naturalised as Australians. So they recommend the status of citizen should be provided for and protected in the Constitution, which it currently isn't. So those 3 areas, those are born in Australia, number 1, 2, natural born or adopted children of an Australian citizen, and 3, naturalised as Australians, are citizens of Australia and shall not be deprived of citizenship except in accordance with a procedure prescribed by law which complies with the principles of fairness and natural justice. Culture, religion and language. Concern was expressed by the committee both by ethnic and Aboriginal groups about the rights of minorities to preserve their culture, practice their religion and speak their mother tongues. These rights should be guaranteed. Australians and equality rights. The concept of equality before the law is a hallowed one in the framework of English and Australian legal and political traditions, going back to Magna Carta. The committee considered whether the Constitution should list particular grounds on which the Commonwealth or a state could not unfairly discriminate. A list might include place of residence, citizenship, race, national or ethnic origin, colour, religion, gender, age, and mental and intellectual or physical disability. However, the committee concluded that might prove unduly limiting. The committee therefore recommends a simple prohibition on unfair discrimination on any grounds. The Constitution should also prevent governments denying equality before the law. That currently happens. The filing fees alone in courts prevent 80 to 90% of Australians from accessing a court by civil litigation. And I have an article to give an example of the judiciary is not working effectively for the benefit of Australian citizens. Thursday, October the 25th, 2012, so it's about 6 months ago. West Australian paper, Rolls-Royce courts out of reach. Incidentally, I believe the commentary of journalists before I believe politicians and judges. The legal affairs editor. WA's top judge has likened Australia's legal system to a Rolls-Royce, arguing it is accessible only to big business, the very wealthy, and a small group entitled to aid, and was out of the reach of ordinary Australians. This is the head of the Supreme Court in Western Australia. In a speech yesterday, Supreme Court Chief Justice Wayne Martin said Australians could take pride in the country's legal system. I don't believe that's true. But many lack the financial and other resources needed to access the justice system. If the justice system was working properly, there wouldn't be all this homelessness, there wouldn't be all this suicide, there wouldn't be destroying the rights of teachers, there wouldn't be locking up people in psychiatric facilities and killing them with dangerous treatments. So there's too much injustice, which is evidence that the judiciary is not working effectively. Quote, Wayne Martin, "It is the Rolls-Royce of justice systems, but there is not much point of having a Rolls-Royce in the garage if you can't afford the fuel to drive it anywhere." Justice Martin told delegates at the Community Legal Centres Association annual conference in Perth, "The hard reality is that the cost of legal representation is beyond the reach of many, probably most ordinary Australians. They can and should take pride in the fact that Australia has a very good legal system provided by judges and magistrates who are independent of executive government and in which corruption is virtually unknown." I don't agree with that. The judges and magistrates are working for the government and the government lawyers and the corporate lawyers, and that's it. So there is corruption. And they're not independent at all. And the case I had in the Supreme Court in my appeal for political signage proves that. 77-page submission in the Supreme Court that I filed. A 77-page submission. I wrote this in 4 weeks. and I'm going to be publishing it as a Bill of Rights book for Australia. In addition, I filed a 17-page submission. That was the first submission I filed. In addition to notices of appeal and oral submission I gave. The judge involved, he lied in the judgment transcript, and he was very dishonest. And at the time that I was going through this, Wayne Martin, the Chief Justice of the Supreme Court, and a second judge, Kenneth Martin, gave an injunction, 2 injunctions to the Liberal Party for political signage all over the state of Western Australia, which resulted in political signage all over the state of Western Australia, and which contributed to their winning that election. And I was the only political candidate in the entire election that was prosecuted for political signage. I was the only candidate out of all Labor candidates, Liberal candidates, Greens. I was an independent candidate. So there is corruption. It is not independent, and it is not a very good legal system, because if Wayne Martin can give an injunction to the Liberal Party for political signage in Western Australia, and a second judge give an injunction, Kenneth Martin, and yet they can prosecute another candidate, an independent candidate like me, that's corruption. And the Attorney General, Michael Mischin, intervened in my case at the invitation of my judge, Judge Hall, who you lied prolifically in the judgment transcript, and you were very dishonest, and I'm going to prove that when I read out this submission to the public. And I'll publish it as a Bill of Rights book. So anybody that wants to read the transcript, I think it's WA 2013, WA Supreme Court 176 is the judgment transcript on the Supreme Court website, if you want to print it off and look at it. It's prolific dishonesty and lying, and I'm going to prove that in the coming months when I broadcast this submission. The Attorney General intervened, using his position, using his tax money to try and destroy my civil political rights. He did it to the Commonwealth brothers, as did the other Attorney Generals around the country. It's corruption, using their position and using tax money to destroy people's basic fundamental rights and freedoms. And they did it because I'm a teacher. And I wrote to them, or the Attorney Generals, and said, if you intervene in my case in the Supreme Court, I will name every corrupt politician involved, every judge involved, and every corrupt lawyer involved. And the only one that did was Michael Mischin. So he arrogantly, deliberately, maliciously did it to bully me and threaten me. And he should be jailed under Section 26F, 26 Section Sub 2, Section 26 Subsection 2F of the Human Rights and Equal Opportunity Commission Act 1986. He can be jailed for 3 months for using his position, using tax money to destroy my civil, political and religious rights, or of any Australian citizen, and the judge too involved. Because the judge in his judgment didn't talk about the urgent injunctions given by Wayne Martin and Kenneth Martin in the same period for the Liberal Party for prolific political signage, did he? He didn't talk about that. But I spoke about it at length. I spoke, 90% of this is a legal argument based on legal texts, 6 legal texts, plus I used the Bible in a small section. I've used all these acts in force. There's about 30 there, 2, 4, 6, 8, 10, 12, 14, 16, 18, 20, about 30 acts in force, and I've used High Court cases, about 50 Australian court cases in the District Court, Supreme Court and High Court in Australia, plus international cases that prove freedom of speech and free political communication, where the judges ruled in favour, and the cases that Judge Hall used in his judgment and analysis were cases primarily where the judges had destroyed people's political speech, free speech. So I use cases that promoted free speech in Australia and international cases, plus legislation that supports free speech throughout Australia, and the judge did exactly the opposite in my case. He used cases and he used legislation to destroy my rights. So he's involved. He should be jailed as well for 3 months for using his position, using tax money, claiming that my claims, allegations were, you know, unsubstantiated allegations of corruption. Well, it is corruption, isn't it? If the Chief Justice of the Supreme Court and a second judge gives an injunction to the Liberal Party for political signage, and yet another candidate is, you know, a Liberal Attorney General, Michael Mischin, intervenes, and the Solicitor General, Donaldson, using his position, he wrote the submission, when the intervener, he wrote the submission, Donaldson, the Solicitor General, and the State Solicitor's Office was involved, so they used that. They made it 6 versus 1. This judge made it 6 versus 1 against me. And in the end, it was to get leave to appeal, permission from them to appeal for my fundamental basic rights and freedoms. I don't think so. In fact, there is no requirement for me to get leave to appeal. I outlined all the legislation where I had a right to appeal, and where the judge, ample legislation where the judge could easily have made orders in my favour for free speech. Not a problem, but he chose not to do that. So he was just siding with the government. That just proves my argument, that they're just siding with the politicians and the government lawyers. And a lot of dishonesty in his judgment. I can prove that. 90% of this submission is a legal argument, including legal text, including about 30 pieces of legislation, including about 50 Commonwealth cases, district court cases, high court cases, Supreme Court cases in Australia, and international cases in favour of political speech. A thorough analysis, and about 90% of it is a legal argument. So he lied, totally lied. And this argument that I presented, I even created a table to show the judge and the other parties involved. I created a table with all the cases that promote free speech, and did an analysis on how it applied to the Cornelute brothers and how it applied to me, and how the government, the Solicitor General and the Attorney General's submission did not provide for the protection or application. So I provided a full analysis. I also provided a full analysis of Lang 1997 implications, which were far-reaching, much wider and far-reaching than what the judge applied, for certain. And also he used cases, recent cases, where the judges have destroyed, in the High Court, have destroyed citizens' rights and freedoms. Monis, he also used Cornelute, where they destroyed, the judges destroyed. So the judges are just as guilty. They're just as guilty as the politicians and the Solicitor Generals involved, using their position, using tax money, to destroy people's fundamental rights and freedoms in Australia. Australian-born people. So I did a full analysis of Lang, and how it applies to Cornelute, and how it applies to me, and how the High Court did not apply the principles in Lang at all. No analysis and application. Not represent a responsible government applied, no personal right acknowledged and applied, excessive legislative incursion, abuse of power, no qualified privilege extended, actively used law to burden freedom, Lang wrongly applied, no rights and freedom applied, natural justice not applied, interpretive methods used in analysis weak and shallow, that was the government, and also for the cases, I'm going to read this out. I'm going to read this out on YouTube in the coming years. It's going to take me several days to work through this, but I want to publish it as a Bill of Rights book. I hope the universities will use it. And factors affecting breach of rights and freedom, I applied all of the other principles, as well as cases. I applied principles, common law principles, no protection given to common law freedom and rights by the High Court or the Attorney General in his submission against me, and the judge, by the way. Procedural fairness principles, no protection given to procedural fairness, freedom and rights. Natural justice principles, no protection given to natural justice, freedom and rights. And principles of legality, no protection given to principles of legality, freedom and rights. High Court cases which promote freedom of speech and freedom of religion as well here, and that they had not applied any of them in favour of the Cornelute brothers or myself. I did a full analysis preceding those tables of the legislation of High Court cases, Supreme Court cases throughout Australia, and district court cases as well as international cases. So a full analysis, 77 pages, plus I've already read this one out on YouTube, the 17-page submission that I filed. And then when they got the government to intervene, the Attorney General, under Section 78B, I also did a section on 78B in my submission. In 4 weeks I wrote this. Appellant's objection to government's use of Section 78B against individual Australian citizens, and I did a full analysis using the legislation and High Court cases, which prove that they're only supposed to use that against the state parliament is only supposed to use that when there's federal trespass against the state's rights. They're not supposed to use it against individuals. So I've proved that in my analysis, but Judge Hall didn't make any reference to that at all in his judgment, did he? If you look at WASC 176, Van Lieshout versus the City of Fremantle, you'll see that there is no analysis. The judge did not refer to my submission, 77 pages, and I used 3 times as much legislation in my argument as the judge did. I used 6 legal texts, including Clark's, Kaiser, Stellius, Hank's Australian Constitutional Law text, and 2013 Craig, Macmillan, Smith 2012 Control of Government Action text cases and commentary. They're the huge legal texts. I used 3 times, well, he didn't use any text in his analysis. I used 3 times as much legislation in my argument, and I used 3 times as many district court, high court and Supreme Court cases and Australian international cases than the judge used in his analysis and judgment. So he totally lied. And he said that my argument was mostly generalisations and a biblical argument. Well, I used a little bit of a biblical argument in some sections here. 1, 2, 3, 4, 5, 6, 7, 8, 9 pages of biblical argument out of 77-page submission. So I use scripture in my argument, but the rest of it is all legal argument. So he wasn't honest at all, and there should be a consequence for that, because why should we accept that? Why should we accept that from politicians and judges who use their position, who use tax money to destroy your lot, to destroy your rights and freedoms, and also to be dishonest? He was dishonest in his judgment, and I can prove that when I read this out to the public, this submission. And anybody who wants a copy can telephone me or email me, and I'll email you a copy of it. But I'm hoping to publish it as a Bill of Rights book. So Wayne Martin claims that Wayne Martin and Kenneth Martin, they should be sacked for this too. They give an injunction to the Liberal Party, yet they use their position to destroy fundamental rights and freedoms for other Australians. So that's corruption. In theory, access to that legal system is available to all. In practice, access is limited to substantial business enterprises, the very wealthy, and those who are provided with some form of assistance. But if you're educated like me and intelligent, highly intelligent and educated, they still treat you like garbage. You use the legislation, you use legal text, you use cases, district court, Supreme Court cases, High Court cases and international cases, and they still treat you like garbage because they don't want you to be right. They don't have respect for people, for the Australian people. It should change. The justice system has to change. It's not a justice, it's not a judicial system. We should have panels of lawyers who engage mediation, and we should have a separate criminal court, a court that deals with just criminal cases, and the other courts do civil litigation, and that everybody should be able to file an action for free, that there's no filing fees or anything like that. So you can file an action and it gets mediated by a panel of lawyers. And there has to be certain principles followed, principles of legality, natural justice principles, procedural fairness principles, common law principles that must be followed. And that the paperwork involved in filing actions and conducting a hearing on an action should be simplified for everybody to use. That would be a better justice system, but it's not working. Justice Martin, who noted that access to civil justice was particularly limited, yes, it's accessible to about 1% of the population. Just the filing fees alone would stop 80% of Australians right there. He said legal aid was limited to serious criminal matters and some family law cases. The main problem with legal aid is, of course, the inadequacy of funding, and it seems unlikely that there will be any substantial increase in funding available to any of the legal aid commissions around Australia in the foreseeable future. The biggest problem is the judges themselves. You know, the fact that this judge thinks he has a right to make me go through nearly a year of hell, file 17-page submissions and other documents, and a 77-page submission, plus documents that I filed that prove that those judges give an injunction, urgent injunctions to the Liberal Party for political signage. The respondent, who was the City of Armidale and the City of Gosnells, didn't even have a lawyer there. They didn't even have a law firm. The judge just gave him an order, gave him an injunction. So I can file that, and then, you know, it proves that. And then in the end, for what? For him to give me leave to appeal, permission to appeal. That's garbage. That's garbage that I would have to go through all of this research and evidence and filing these submissions to get his permission or any judge's permission to file my appeal. That's like feudalism. I don't have to seek permission from a judge to file an action. It should be an automatic right. Any Australian should automatically have a right to file an action. And if you have to seek permission from a judge to file an action or an appeal, it's like slavery, isn't it? There should be an automatic right to file an action, either as a plaintiff in an action or an appeal, in any case, whether it's civil or criminal. And this idea that you have to get permission is garbage. I didn't have to get permission. The legislation that I outlined gives ample provision for any judge in the Supreme Court to make orders in my favour, and I will read all of this out to the public to prove that there is ample legislation for them just to allow the appeal to proceed and to provide orders in favour of the appellant for whatever purpose, in the name of justice, in the interest of justice. So that's another error that Judge Hall made. That's absolute garbage. Justice Martin said that community legal centres played a vital role in bridging the gap between the courts and their communities, drawing on the High Court Malaysia solution case taken on by lawyer David Mann from a refugee and immigration legal centre in Melbourne as an example of their importance. Well, the problem is the rights and freedoms of Australian citizens, Australian-born citizens, are being abrogated by the government and by the judiciary. And the evidence there for the Aboriginal people, they've been locking up the Aboriginal people for 200 years, killing the Aboriginal people, stealing their land, stealing their children, families after families, generations of families incarcerated, high rates of suicide, high rates of incarceration, no real economic participation, or not enough, not enough jobs, not enough attrition to education, tertiary education. That's what the politicians have done, and the judges, and the magistrates. So the incarceration of the Aboriginal people is an example of the breach of rights, fundamental freedoms and rights, human rights in Australia, of the Australian-born people. Forget about the other people who are coming here. They're not even Australian citizens. I'm talking about the Australian-born people and people that have lived in Australia for a long time, for many years. Maybe they came here as children, or, they've lived here for 30 or 40 years and are real Australians, not the people who are trying to come here illegally. So we need lawyers to fight for the Australian-born people and people who have lived here for many years, citizens who have lived in Australia for many years. The rest can pretty much get in line as far as I'm concerned. So there's, it gives an example of a lawyer who is fighting for the rights of not Australian citizens. Resourcing limitations necessarily mean that the community legal centres are incapable of fulfilling the large gap of unmet legal need, he said. This means the courts must do whatever we can to improve access to justice. Well, generally speaking, they don't. They make it very hard. They make it as hard as possible for you. And the fact that they've done it to me, educated person, intelligent, is evidence that they don't want more people to have access to justice. Because if they can do what they did to me, they can do it to anybody. Community Law Australia spokesman Hugh de Kretser said the urgent need for action to help people deal with legal problems had been highlighted by a recent survey of more than 2,000 West Australians. Mr de Kretser said the survey revealed that West Australians were slightly more likely to experience legal problems than those in other states and less likely to seek legal advice. That is the fault of politicians and judges and magistrates who have created a political and legal system which excludes 90% of Australians. And that's what the evidence shows. So they should go. They should be sacked. And we should have new people in there and a lot more accessibility to courts, filing hearings for free, make the paperwork a lot easier, have a lot more mediation, a lot more lawyers. Because they put themselves, the politicians and the judges put themselves up here. They put the teachers right down here, they destroy the teachers' rights. So they do that, they destroy the education system. And that's what they're doing. They're lording it over the people by putting themselves up here, politicians and judges and magistrates. Just working for the government, working for the corporate sector, and everybody else is down here. And it's wrong. And what the consequence of that, people suffer, and there's a lot of death in our society, which they are accountable for. They are accountable for a lot of this death because of their bad leadership. And by creating a very selfish political and judicial system which does not provide accessibility to the Australian people. So there needs to be significant reform, and it has to be done politically, and also the judiciary needs reforming. Other issues that that this commission addressed: freedom of religion, freedom of movement, access to courts, parliamentary privilege, which I believe they shouldn't have any privileges, and that we should slash the salaries of politicians and the perks that they get. And after they leave office, why should they get perks? Why should they continue to have travel allowance after they leave the parliament? Why should they continue to get exorbitant superannuation entitlements? All the perks that politicians give themselves. You know, they've just got another pay rise recently. It's just more evidence that they're corrupt, and that why should we allow that? They should all be slashed. It should be slashed right back. Freedom of political speech, freedom of information, peaceful assembly, citizenship, culture, religion and language. Socio-economic rights they address: private property, economic rights, social rights. Operation of proposals on all levels of government. Australian constitutional change, a greater voice for the people. That's what this commission proposed. It provided arguments against a new voice for change. It provided arguments. So they did a lot of good work in this commission, and the 5 advisory councils. A lot of good work was done. It also proves that the federal parliament is not functioning, particularly the lower house, is not functioning the way it should be. And also the role of the Senate is really, there should be a lot more media coverage of the role of the Senate too, and the Senate should intervene a lot more vocally when the House of Representatives is not working properly, or the senators should ensure that, you know, continually enforce the use of the Constitution and hold House of Representatives politicians to account in the states and federally as well. There should be a much greater role of senators to hold lower house politicians to account for their work and for their rhetoric. Also, the Governor-General needs to intervene more in what's happening in the Parliament, because essentially the Governor-General has more power than anybody in our nation. Appoints ministers and dismisses ministers, not the Prime Minister. The nation is supposed to be governed by a federal executive council in the lower house, House of Representatives, federally. There is no mention of cabinet in the Constitution, and there is no mention of the position of office of Prime Minister. You can scrutinise the Constitution to prove that what I'm saying is true, and I stand on the evidence provided by all these professionals in the Constitutional Commission that I read out at the beginning of this broadcast, and the people involved in the 5 advisory councils, former politicians, judges, QCs, and professors in law, and other professional people who've contributed, a very significant amount of people who've contributed to this report. So it's very accurate, it's very reliable, and it's really worthy of analysis. Thank you very much.